Good evening, esteemed guests. So,
Good
can you
evening. Good
turn on
evening.
your camera? Kaustav, sir. My name is Preetinim from the Law Advice, and I extend a very warm welcome to each one of you joining us today for this very significant virtual seminar. Today, we are privileged to convene into a discussion on the topic of the three newly introduced criminal bills and their implications. It is with great pleasure that I introduce our esteemed panel of experts for today to deliberate and guide us for a better understanding of the three new laws. I welcome Honorable Justice S.K. Keshote, Senior Advocate Kaustav Paul, and Dr. Parmendra Dhadhich. It was on August 11, 2023, when the central government proposed three new bills aiming to replace the Indian Penal Code, the Criminal Procedure Code, and the Indian Evidence Act of the country. The bills were subsequently passed by both the houses of the parliament, later on receiving the president's assent. The new bills, namely the Bharatiya Nyaya Sanhita Act, just a second, sir. Good evening, sir. You're not audible. So, On August, I'll just on August 11, 2023, the Center proposed three new bills aiming to replace the Indian Penal Code, the Criminal Procedure Code, and the Indian Evidence Act of the country. The bills were later on passed by both the Houses of the Parliament, later on receiving the President's assent. The new bills, namely the Bharatiya Nyaya Sanhita Act, the Bharatiya Sakshya Act, and the Bharatiya Nagrik Suraksha Act, have introduced significant changes to the criminal legal framework of our country. The Bharatiya Nyaya Sanhita Act, replacing the Indian Penal Code, has seen modifications in 175 sections, including the addition of 8 new sections and the repeal of 22 sections. Similarly, the Bharatiya Sakshya has amended 23 sections, introduced one new entire section, and removed 5 sections. The Bharatiya Nagrik Suraksha Act, replacing the Criminal Procedure Code, has repealed 9 sections, introduced 9 new sections, and made changes to a total of 160 sections. Recognizing the potential challenges and uncertainties that may arise among practicing lawyers, students, judges, police personnel, and others. The law advice here has organized this platform to provide insights and perspectives from our esteemed experts. Let us engage in this constructive dialogue and explore these crucial legal reforms. Sir, if I may.
Yes.
So, yes, sir.
So first, why to start? Who will do? First, who will do?
Sir, I'd like Justice S.K. Kishore to
Okay.
start.
Thank you.
Yes,
Thank
sir.
you. So I will talk on the Bharatiya Sakshi Act. After this, this development in the this media, this recognized electronic media development, law development. I think that this provision introduced for this use of all the electronic mode in the evidence in trial investigation, all these things, I think it in my view appears to be a requirement of the day, because we are also dealing with the cases. Mr. Professor is also Caustic also dealing with the cases. In large cases, I'm doing, particularly after retirement, I'm not doing the many legal matters, but I'm doing the many arbitration matters. And in each and every arbitration matter, we find emails, this media.
So we cannot hear you, sir. You're not audible.
I think he's been muted. So we're not being able to hear you. I think, sir, you're muted. You'll have to unmute yourself.
Please unmute. Mute. So please unmute your microphone. It's on mute. Click on microphone. Please click on your microphone button. There's a microphone button on your screen. So there's a microphone icon right there. So in the meantime, while we deal this, can I please request Kaustav sir to present his views upon the topic?
Good evening, respected panelists and the viewers of Law Advice. Uh, while Honorable Justice Keshote is having a little technical issue, I reckon. Uh, Let me just start by I think we've all been given a little backdrop about these three new laws that are set to change the course of criminal dispensation in India. Uh, the two primary things that and what I thought is the topic for the day is the difficulties that are being faced by legal practitioners, the students, the honorable judges, and the common man and such, insofar as implementation of these laws are concerned. Now, as we are all aware that the central government has just notified these laws, but there is a respective clause in all these three acts which says that the respective provisions of these laws would come in at a subsequent date, as and when they are notified by the central government. Uh, and that is yet to see the light of day. And so we still essentially going by the Indian Penal Code, the CRPC, and the CPC. So my effort here would be, that it's like an ocean in front of us at the moment, uncharted territory, and uh, uh, I wouldn't say a detailed, but rather casual, scrutiny of certain provisions of these particular laws that I thought was important for day-to-day practitioners. I thought that I should address my limited understanding of these provisions to you all. Now, very interestingly, when we open the Bharatiya Nyaya Sanhita, which is to replace the Indian Penal Code, uh, and I draw specific reference to Section 1(5) of the particular act. Now, a very interesting preposition for the first time is mooted by the Indian legislature, where they propose that for any offense by an Indian citizen, even if it is committed outside the territorial jurisdiction of India, he could be tried under Indian laws. Now, what is very perplexing is there is a concept of certain international law, private international law, where we recognize that an offense committed in a certain country would be dealt with by the laws of that particular country. And that would be one of the fundamental principles of sovereignty, which is again recognized by the Constitution of India. Now, the legislature, in its own mind, and I'm sure there have been very active minds working on it, has brought in a provision, and it says, and since it's a new provision, I'll just quote from here, and I quote. This is Section 1(5). It says that the provisions of the Sanhita apply also to an offence committed by any citizen of India in a place without and beyond India. So we are looking at we're looking at a concept of where I, as an Indian, am to commit an offence outside the territorial limits of India, and B, they say, any person or any ship or aircraft registered in India, wherever it may be, any person in any place without and beyond India committing offence targeting a computer resource located in India. And then there's an explanation which says, in this section, the word offence includes every act committed outside India, which, if committed in India, would be punishable under the Sanhita. So, for the first time, we're looking at a concept of where an Indian national commits an offence outside the country, besides prosecution in the country where the offence is committed, there would also be it would also be an offence, and there would be investigation and trial under Indian laws. I don't know to what extent this would hold water subsequently. That we'll have to examine the subsequent court, but this is what the legislature has brought in. Now, if we go into the Bharatiya Nagrik Nyay Sanhita, which is set to replace the Code of Criminal Procedure, there are some very interesting thoughts that came into my mind. I'm sure all of you must be watching the various opinions of experts on this. Now, what? Let's just take two provisions, for instance. Now, the first provision, which I thought was important for legal practitioners, and it is bread and butter for a lot of people, is anticipatory bails. Let's just talk anticipatory bails. Now, anticipatory bails under the present Code of Criminal Procedure is dealt with by Section 438 of the Code of Criminal Procedure. That is sought to be replaced by what would now be Section 482 of the BNSS. I'll refer to it as BNSS. Now, there are substantial changes that have happened in the BNSS from what was there under the CRPC. Now, what they have done is, earlier under the CRPC, there was a mandatory requirement of hearing the prosecution so far before a final order of bail is passed, anticipatory bail is passed by a competent court. Unfortunately, under the new laws, probably the legislature or the select committee to whom it was referred lost track of the fact that these certain provision, which was brought in by way of an amendment amending Section 438, subsequently requiring mandatory notice to the prosecution, has again been left out insofar as the BNSS is concerned. So there would be instances where I would be accused of a certain offence committed in place A. I would go to place B, and I would obtain some kind of bail from there without the prosecution of place A, which is the competent investigating agency, actually being served notice by the court. Now, I would like to share an anecdote of a certain case that we did very recently, and the Honorable Supreme Court has delivered a very lengthy judgment insofar as this aspect of the matter is concerned. It is a matter called Priya Indoria versus State of Rajasthan. Now, there what had happened is an FIR was filed in Rajasthan. The accused family used to stay in Bangalore. So they approached the Sessions Court in Bangalore and obtained an anticipatory bail from Bangalore in respect of an offence which was registered in Rajasthan. That matter came to be challenged before the Honorable Supreme Court, and the Honorable Supreme Court, while examining the detailed law on the issue, has given certain findings. One of which is that without hearing the prosecution, any orders could not have been finally passed. Now, the BNSS somehow has lost track of this, and what has happened is, now the provision of the BNSS Section 482 as it stands does not require the mandatory hearing of the investigating agency of the place where that, or the state where the offence has been registered. In my considered opinion, this would lead to manifest miscarriage of justice. So while the legislature was indeed amending the law to make it more compatible to Indian circumstances, what it has essentially left out is, and that's very unfortunate, because what I'll say subsequently also would probably reflect this, that the pronouncements of law on the issue have somehow been lost track of by the legislature. So this is something that would create a lot of confusion amongst courts, councils, and clients, litigants all across the country. Now, one very significant introduction in the BNS is the introduction of a certain provision called Section 69, which says that engagement of anybody in any kind of personal sexual relations with a person on the pretext of marriage would be a punishable offense, and it would entail serious punishment. We are all aware, as I'm sure the group which we are addressing this webinar on is a group of people who are closely associated with law, if not lawyers and judges, students of law. Now, we're all aware that in India, there's this sudden surge of unfortunate false allegations in this regard being made, and frivolous complaints being lodged with the police and courts all across the country on this limited pretext that, yes, me and he were having this kind of a relationship. For some reason, the relationship went sour, but one of the aggrieved parties goes and says that no, there was this intimacy between us, but the intimacy was on the pretext of marriage. Now, the Honorable Supreme Court, as well as the various high courts of the country, have repeatedly cautioned the investigation, saying that there has to be a detailed scrutiny regarding the conduct of the parties. And certain parameters have been set insofar as investigation into these kind of cases have been concerned, because there has been this trend. There was a time when the formulation of Section 376 was on the premise that once a lady comes out of her house and actually makes an allegation of rape against somebody, it had to be the gospel truth, because an Indian lady will not come out on her own and make some kind of an accusation like that. It was on that premise that this law was existing. With the evolution of time, what has essentially happened is there are repeated judicial pronouncements where this provision has been manifestly misused by people for their own personal gain. And certain parameters have been set by the courts, saying that when you are investigating this kind of offense, these checks and balances have to be examined before you actually go forward. Unfortunately, now for the first time in India, Section 69 of the BNS is introduced, which becomes a punishable offense. And the safeguards which have been laid down by judicial pronouncements, unfortunately, in my humble, in my considered view, has not been taken note of by the legislature. So again, we go back to square one. As I said in the beginning, it is an uncharted territory. And every provision of this BNS or BNSS would again have to be examined on the touchstone of judicial scrutiny. Another very interesting fact, which I thought that what was the need of bringing in this kind of a law, replacing something which is 200 years old, was to avoid frivolous litigation. One of the things plaguing the Indian judicial system is there is a lot of frivolous litigation happening all across the country. And that tantamounts to courts being burdened, genuine cases suffering, litigants suffering. And what was made famous by a movie of Sunny Deol, Tariq Pe Tariq, that is something which has become part and parcel of our Indian judicial system. Now, if we were to change the law and bring in something new which could substitute what is the present position of law, we had to discourage people from initiating frivolous litigation or litigation with some malified motive. Now, the only provision under the IPC that had to deal with this was perjury, and we can go back to section 193 of the IPC. Now, what is shocking is, if we are trying to bring in a law which would deal with this, I'm sorry. Now, section 229 of the new Bharatiya Nyaya Sanhita, which is to replace the IPC, again deals with perjury. Unfortunately, the punishment as was prescribed under the IPC has been reiterated under this new BNS. So in essence, we are not looking for anything new. And as the saying goes, it is essentially old wine in a new bottle with a little bit of packaging. Now we'll have to see how far this packaging will hold water in proceedings before courts, and the courts would have to spell out regarding the constitutionality or otherwise of these laws. My closing remarks on this would essentially again be this: that we are on uncharted territory. We don't know where we are going. The central government is yet to even notify the dates under which these provisions would come into effect. And so therefore, we are, in a state of fix insofar as legal practitioners are concerned. We are in a state of fix, not knowing how it is going to be implemented, when it is going to be implemented, and what would be the course that would be appointed by the government of the day insofar as implementation of these laws are concerned. And before I end, there is a little something, because I personally come from the Northeast. Now, as I told you all before this little webinar, I was just taking time out to look at where the BNSS, or what is the Criminal Procedure Code, how it is to be implemented. Now, very interestingly, and I think this would interest my friends from the Northeast. Now, it says, Section 1 says that it is applicable to the whole of India. Now, Section 1(2) says it does not apply to the state of Nagaland. Now, that has been the consistent position of law in view of the 6th schedule to the Constitution of India. Now, subsection B of Clause B of subsection 2 of Section 1, again, interestingly says it does not apply to the tribal areas. Now, the tribal areas are defined by the Constitution, Schedule 6, Para 20, which would also include certain portions of Mizoram, certain portions of greater areas of Meghalaya, and of the undivided Assam, because the cutoff date as per the new act is 1972. So we would all recollect that 1972 is when the Reorganization Act came into being, and the erstwhile undivided Assam gave birth to at least 3 states. We're talking about Meghalaya, we're talking about Mizoram, and they are all having tribal areas. Now, certain parts of this law, specifically Chapter 9, Chapter 11, and Chapter 12, which deal with public law and order, have been left out of operation insofar as the northeastern states are concerned. And we would all be aware, especially in view of the recent spate of violence in the state of Manipur, which again has tribal areas, as to how public order is to be governed. So these ambiguities in the law, I think, would be best dealt with by the government of the day. And, as a council, I can only say this, that, all these provisions would have to be tested one by one, because what this law has essentially done, and that's my personal opinion, it's set to replace something that has crystallized over 200 years. So 200 years earlier, some law was made by Lord Macaulay. With the legal system comes into place. Time and again, every full stop, every comma, every colon appearing in every provision has been examined by the courts, interpreted by the courts, where there was a lacuna that has been filled in with judicial pronouncements. And we have a certain system in place. Now that is sought to be replaced by this new law. So I think it's a little early in the day to comment any further on this. And, I leave it to my respected panelist, Justice Keshote, who has the vast experience of administering justice in 3 different high courts. He would throw better light on this. Thank you so much.
Thank you, Kaustav. Thank you very much. You talk about the penal code. So I also like to say something about the penal code, only for one provision that was introduced for the hit and run accidents, motor vehicle accidents case generally. And if it was made a severe offense, punishment is also needed. But this lawmakers has not considered one important aspect. Now, on roads, thousands, crores of the lakhs of the vehicles are, are there on the roads. And more particularly, there are two types of motor vehicles. One is the heavy vehicles, another is the light vehicles. I'm more particularly talking about the heavy vehicles, trucks. If there is an accident and by that accident somebody killed, what the driver will do? You have the experience. All advocates experience, lawyers, judges, citizens. If the driver after accident stay on the vehicle, not run away, what will happen? What will happen? You all the panel members know very well what he will do. For the purpose of the law, for the purpose of law requirement, he will stay there. Please, I am the person committed the offense. I am before you. That what they will do is they will kill him.
They have to flag.
We are seeing every day. We are seeing that this aspect was not considered. If the vehicle is met with the accident, they will not spare the driver and they are not sparing the vehicle. What they will do first? Put the vehicle to the fire. This aspect was not considered. What do you say? I don't know. This is my feeling that I think that aspect was not considered. People will, finish the work of the prosecution. By this provision, one thing
Spot
is
justice.
what you said?
No, I said spot justice, on the spot justice.
In court, yes, if then it should have been made a clear provision there. You are free to kill him. Spot justice. Do yourself. Then what for this prosecution? What for this prosecution? So this aspect of the, I don't know, there are very learned people are sitting. Number of people would have considered. Either they have not experience of the roadside, or they ignore it. So in my view, this IPC provision, which now been made amended, that seems to be very illogical, and real position on the roads in such matters was not taken into consideration. So I will talk because I have no time to read these provisions. Nobody has made available. So I have not studied deeply all these provisions. But so far the Evidence Act is concerned, that is 1872 Act. Certainly after 1872, it needs a considerable consideration to make it as what today the need is of the law. So I think that evidence that to that extent seems to be reasonably considered, and certain provisions which need to be there. In my view, it was included that is the first regarding the BS recognizing electronic record as primary evidence under section 57. This electronic record is now in each and every case, you will find the electronic record. Though I retired about 18 years back, so I have not experience of dealing with the case as a judge. And also I am not dealing with the cases in large number in the Supreme Court also. That much of brief I am not getting, I was not taking. But I am dealing with the arbitration matter each and every day. And there is, electronic, this documents, electronic board documents are in large numbers. One of the matter I am dealing with, 5,000 documents, 5,000. If they go on proving it that way, how much long time a litigant will take to prove it? So that seems to be a reasonable provision. Then another use of that part is concerned. This seems to be that part of this section which allows experts, appointment to experts. That seems to not reasonable. We cannot give this recording of this documentation by electronic mode to the outsiders, private persons. That will, I think, in my view, seems to be not reasonable for the region. That there is very difficult to have the faith, confidence, and fairness and honesty, because the people's we are also having the you know against the judges, we are having the everyday you people, more particularly bar and litigants making the all complaints. Then if it were given to the private person in hands, then it seems to that part seems to be not very fair in the situation presently in the country we are having. But rest of the things seems to I have not studied that much so deeply in matters, so I am not that in a position to say much about it. But it needs a amendment, and reasonably whatever the provision just I get from the this is ये आपका से seems to be reasonable, and I think it will work and expedite the trials and inquiries, all these things. Thank you very much. Thank you.
Rightly said, sir. May I please request Dr. Parmendra to take the discussion forward?
I'm really enlightened today to gain the knowledge which has been imparted by the honorable panelists. And I'm actually here more as a law student, not as a jurist or any other person. Right from the ancient times, there are two things which are very clear. Law was always considered as dynamic. Moreover, existence of advocates. It was there in the ancient law also. This has been because in Ramayana also in Ramcharitmanas, it is stated that Sachiv Vaid Guru Teen Jo Priya Bol Nahi Bhai Aas. So Sachiv, these were actually advocates, or you may say ministers. And Manu is also regarded or considered to be the first jurist to introduce codified law, although many persons do not agree with his knowledge and thoughts. Moreover, after this Sevigny, F.K. von Sevigny, who was actually the propounder of the Vogt theory, uh, he, I want to quote him, he stated in his theory of Vogt, the law is the product of people's life living in a particular society, and it is the outcome of a culture of a society. It embodies the history of a nation's culture and reflects inner convictions rooted in society's common experience. He also opposed codification of German laws because, as according to him, codification is the last stage of development of legal propositions law, and according to him that stage did not come at that time. In India this stage reached previously in the year 1772 by when Warren Hastings he codified certain revenue laws. Now in 1860 Indian Penal Code was drafted, 1872 Indian Evidence Act, and thereafter in 1898 the old law, that is to say the CRPC, it was also drafted. Now being a law student, because I cannot come uh, out of my I cannot be out of this class because I'm a student always. I will be a student. Now all these students which students consider to be major acts, these are actually considered to be major acts when they prepare for judiciary, or whenever they prepare for any examination, and for an extensive study. At least 7 to 8 months studies is required to have a deep knowledge in these laws, CRPC, evidence, and IPC. There are many other renowned coaching centers which take almost 1 year to cover up all these syllabus of judicial services examinations, and most of the time is actually given to these three laws only. Now, in most of the law schools and colleges, there are 2 semester studies for CRPC and also for Indian Penal Code, and 1 semester studies for Indian Evidence Act. Now, being an advocate, we devote our whole life in learning these laws, and we learn a sequence and numbers. I mean, that when we were the law students and we saw how these numbers are in our subconscious or unconscious minds. Actually, whenever we saw any drunkard person, we used to talk in code words. We do not speak directly, and we used to say, "Look, Section 85," because Section 85 is an exception of drunkenness. So, in the same way, if we saw any mentally retarded person or any other person, we used to say Section 84. Likewise, whenever one day my friend asked me what is your address, so I told him that my house number is 302. Then he said, "Oh, I cannot forget it for my whole life because 302, because he is actually a criminal lawyer." So, in this way, the sequence and numbers of the old law was in our unconscious mind as well as in our blood. Now, in the year 2023, all these criminal major acts, I call them criminal major act because I am giving the version of law students. So these major acts have been replaced by new law of 2023, which finally received assent of Honorable President on 25th of December 2023. Now, before going to the subject, that what are the actually difficulties faced by law students, I have gone through these acts. Apart from arranging, renumbering of sections and organizing chapters, there are few changes introduced by the new laws. Some of these changes were actually previously covered by existing old laws also, because our panelist, Honorable Kaustav sir, actually stated that sexual intercourse on the pretext of marriage, false pretext of marriage. Now, this was already propounded by Honorable Supreme Court in Jayanti Rani Pada. It is very old case. So these changes were previously covered in existing old laws by various judicial pronouncements. There are certain difficulties also now faced by all the law students and advocates. Advocates are basically a productive assets of the society. Our society is very much compromising society. They adapt to the prevailing difficulties, nuisance, social evils, but advocates do not compromise with these situations, and therefore they want drastic changes in conformation with law. And therefore, we advocates are not we have not accepted, we are not actually accepted class of the society. We are not usually accepted. We are not given offices for rent, residence for rent, because everyone see us by some suspicion. Now, the first problem that I see with the present changes introduced by the new laws, I'm actually more concerned for the students appearing this year for their LLB exams and are going to appear for Indian Penal Code, Evidence Act, and CRPC as well. These they will appear in those examinations knowing fully that after writing their papers, these laws will be replaced by the new laws, and moreover might be useless in extent, some sense, because at least numbers will be without of any use. Now, the legal studies is very expensive, and the law students appearing in judicial services have made huge expenses in studying all these laws, and are in a state of total confusion about the future of the existing old laws. That is actually the difficulty. Even the Bar Council and universities have not taken any cognizance of their grievances. I think Bar Council and universities at least must do something to make them aware of the new laws and make the new laws a part of their curriculum or syllabus. Secondly, lack of legal awareness is also one of the problem. It is a problem because one of my friends suggested, because since I was expending my resources, the law books of my office library, so he said that now these books are going to be replaced by some other books, so these will be useless. Don't make some such expenses upon books. But I think he was unaware about the rule of interpretation, that is pari materia. Pari materia, it means on the same subject or matter in a similar manner or similar case. It is a doctrine of statutory construction that statutes that are in pari materia, similar sense, these must be construed together. Moreover, the last difficulty that I have gone through, This is not this is not basically a difficulty, but this actually aggravates the difficulty of the law students. See, the law colleges are not having basic infrastructures. They are not having the minimum teaching faculties. They're not having the required buildings, and these colleges are actually being run on papers. So these are basically the problems, and I think when going through these all these laws, the students may overcome all these difficulties by the webinar that we are organizing. Moreover, some in this respect, I must say that this law advice has conducted a very relevant. It is very relevant at this time because the students are actually facing this problem, and moreover, this problem may also be carved by legal education. The most relevant thing, which I must say, which can overcome this difficulty, is the legal education, which the students are not having actually. So that is all from my side.
So, anybody else would like to add something to the discussion? Any final remarks?
Just to take, something that crossed my mind, I thought I should share it. What Professor Dhadhich just said, that the provisions of the existing criminal major acts have become have become part of the day-to-day parlance in this country. Now, if somebody is trying to cheat somebody who is a known habitual cheater, we don't call him a cheater. वो तो 420 है. To the extent, this is on a lighter vein. Guru Dutt, in his famous movie of Devanand, I picturized Devanand, Shriman 420. So these provisions had become synonymous with the offences and what they are related to. Now replacing them, as a council, and I think Honorable Justice Keshote would agree. We're very habituated in addressing the court of this is this, and so therefore this section would come into play, and this would not come into play, and this provides for this. So I think we'd all have to train our minds to again redo the calculations of which provision deals with what. And I'm sure for at least some time there would be some difficulty faced by all legal practitioners insofar as their arguments are concerned, and how we refer to the specific provisions of law. That would definitely come into way. Also, I thought that what Honorable Justice Keshote was saying, and also Professor, that there are we cannot be really be very negative about what has been done by the legislature, and I personally thought that in my last session I was very critical about the laws that have been now sought to be brought in. At the same time, as Honorable Justice Keshote said, that there are welcome changes of integration of technology into the laws. That I think is definitely a very important aspect of the law, and as most of my friends who are watching would be aware, that now with any offence above 7 years, it has been made mandatory. Any offence which has a punishment of 7 years and above, it has been mandatory for forensic audit. Now, that I think, as a practitioner, as a legal practitioner, we've all faced situations where it becomes very difficult to establish that a certain document or a certain act was not done by me without going through, and which would actually lead to a lot of false prosecution. Now, with this introduction of this particular aspect of the matter, where there would have to be a forensic study of forensic evidence insofar as prosecution of these offences are concerned, where punishment is above 7 years, including Section 420, since I was just referring to Section 420. I think that's a very welcome development, and the integration of technology or the recognition of technology into law that was for some time, coming, and we needed it because with most of the documentation these days being on electronic records, it was important that it was recognized. So, what would you say about this, sir? Honorable Justice Keshote.
So your mic is on mute again, sir. You have to.
Yes, Mr. Kaustav.
No, sir. I was just talking. You addressed us on the issue of integration of technology into the law.
Yes, sir. It is a need of the day. It is a need of the day. It has to be. It has to be. At least personally, I welcome it. I welcome it.
We all do, sir.
Because I'm dealing with the cases and I'm facing these problems. In arbitration, virtually we are facing the problems. We are dealing with one of the your arbitration. We are dealing with one of the arbitration. There are thousands of documents, electronic media documents you produce. So each document, if we go that way, forensic method is not used, all these things not used, it's very difficult. The primary evidence is made is I welcome this provision. I don't know. Ultimately, as an advocate, you welcome, not welcome. But I have dual capacity as a judge and as well as advocate. I have a doubly experience. So
we have to welcome it because these days
yes.
most of the correspondence is on mail.
Yes,
It's on electronic medium. So
allow not only correspondence, even on the documents, your agreements, contracts, everything is on electronic media. So other things, so that part is concerned. If we sit together and talk together, after going through each and every provision, we can find so many lacunas there. Very difficult to make a law without lacuna. And so what that part is concerned, you advocates are there only for finding out the lacunas.
we'll be there to dig on the lacuna, sir.
Moreover, sir, the most welcoming section is 152, which actually punishes acts endangering sovereignty, unity, and integrity of India. Because we have witnessed the JNU incidents.
Yes,
and when any person shout before a crowd, very very well known University of India, that तेरी बर्बादी तक हमारे मतलब ये टुकड़े होंगे and all.
Every day we are having now this up to election you will thousands of this types of the things.
Exactly.
Yes.
JLN.
Why your JLN? But why not the Aligarh Muslim University?
Yes, sir.
So anyhow, thank you very much to all of you.
Thank you, sir.
For joining.
Thank you, sir.
Thank you, sir. In conclusion, I guess the success of these acts, these reforms, hinges upon meticulous implementations, clear directives, and the ongoing oversight to ensure that they serve their intended purpose without any repercussions. Sir, it has indeed been a very informative session, and it's very difficult to sum it up in just 1 hour. And we would definitely want to seek your guidelines in future upon this topic for a better understanding of the intricacies and the concepts. We would here include this webinar. So it was a pleasure to have you with us. Thank you all for attending.
Thank you for having us.
Thank you, sir.
Thank you.
Thank
Thank you.